The EU AI Act Newsletter number 53. The law is finally adopted. By Risto Ook. Subtitle: The Council of the EU approved the AI Act, and the law will now enter into force very soon. Heading: Legislative process. AI Act is finally adopted. The Council of the EU approved the AI Act on May 21st. This legislation, the first of its kind in the world, adopts a risk-based approach, imposing stricter regulations on AI systems with higher potential to harm society. The Act aims to standardize AI rules, potentially setting a global standard for AI regulation. Its primary goal is to promote the development and adoption of safe and trustworthy AI systems within the EU's single market, ensuring they respect fundamental rights while fostering investment and innovation. However, the Act exempts certain areas such as military and defense applications and research purposes. Mathieu Michel, Belgian Secretary of State for Digitisation, Administrative Simplification, Privacy Protection, and Building Regulation, highlights the Act's emphasis on trust, transparency, and accountability while ensuring this fast-changing technology can flourish and boost European innovation. Once signed by the Presidents of the European Parliament and of the Council, it will be published in the EU's official journal, taking effect 20 days later, with a 2-year implementation period, with some exceptions. Heading: Analyses. Areas of convergence and divergence between EU and US. Benjamin Cedric Larson, AI and Machine Learning Project Lead at the World Economic Forum, and Sabrina Cuthbert, Policy Officer at the European AI Office, European Commission, published an overview on the Brookings Institution's website, highlighting both commonalities and disparities between the EU and US approaches to regulating general-purpose AI. While the US executive order focuses on guidelines for federal agencies to shape industry practices and reporting requirements under the Defense Production Act, the AI Act directly regulates general-purpose AI models within the EU, with legally binding rules. The executive order can be modified and revoked, while the AI Act is a lasting governance structure. The EU's threshold for regulated general-purpose AI models is lower than that of the US, potentially encompassing a wider range of models. The US approach focuses on AI's dual-use risks and potentials, but the EU's Act takes a broader view of systemic risks and includes discrimination at scale, major accidents, and negative consequences to human rights. Both frameworks are aligned on the need for documentation, model evaluation, and cybersecurity requirements. The AI Act's global influence could parallel that of the GDPR due to the importance of the European market. Conversely, the US order primarily sets domestic policy with indirect global influence. Both entities, along with other G7 countries, have committed to creating a non-binding AI code of conduct, signaling increased collaboration on AI policy. Open-source AI exceptions. Lawyers on the Oryx AI team Julia Apostle, Sarah Schettler, Shea Afshar, and Daniel Hilo wrote an overview of the exceptions in the AI Act for AI systems released under free and open-source licenses, which excludes those that are high-risk or interact directly with individuals. General-purpose AI models can qualify for a limited open-source exception if providers enable access, usage, modification, and distribution of the model's parameters. However, they must not present systemic risks. Benefits of the exception include exemption from transparency obligations, but providers must share detailed training content summaries and comply with EU copyright law. The authors say that when contemplating a strategy for open-source AI, developers, providers, and deployers should consider the types of AI technologies being used, the pros and cons of licensing under open-source licenses, and the necessary safeguards when utilizing open-source AI technologies. Spotlight on biometrics. David J. Oberle of counsel in Baker Donaldson's law practice wrote that the AI Act imposes strict regulations on biometric systems, bans certain use cases, and extends its reach extraterritorially to companies beyond the EU. Oberle states that biometric technologies such as identification, verification, and categorization are directly regulated, while there are prohibitions on systems related to sensitive personal attributes, emotion recognition in workplaces and schools, AI systems that expand facial recognition databases, and real-time identification in public spaces. High-risk and transparency classifications impose additional obligations, including visible notices for data subjects and marking outputs for synthetic content. He advises companies involved in biometric systems to proactively work toward compliance with the Act, with several recommendations in the post. Heading: AI Office. Vision for the AI Office. Philipp Hacker, Sebastian Hallensleben, and Kai Zenner published an op-ed in Euractiv arguing that the implementation of the world's first comprehensive AI legislation requires robust leadership and an innovative structure. Hacker, Hallensleben, and Zenner state that the AI Office, facing numerous challenges including tight deadlines and limited budgets, must be designed with a clear and strategic structure to fulfill its mission effectively. They propose a structure comprised of 5 specialized units: trust and safety, innovation excellence, international cooperation, research and foresight, and technical support. In addition, attracting and retaining top talent, including from outside EU institutions, is crucial, necessitating appealing work environments and arrangements. Leadership should combine institutional knowledge with AI expertise, supplemented by external advisors. Operational values should prioritize agility, minimal bureaucracy, and autonomy, akin to successful startups. They also highlight the importance of securing cutting-edge hardware and software through innovative procurement methods. Finally, the authors call for transparency and accessibility to foster regular interactions with various stakeholders, including EU citizens, civil society, academia, and SMEs. Robust governance ideas. Academics Claudio Novelli, Philipp Hacker, Jessica Morley, Jarl Trondle, and Luciano Floridi suggest several enhancements to the governance of the AI Act. Firstly, they propose clearer guidelines for the structure of the AI Office and expert selection process. Secondly, they advocate merging the forum and panel into a single body to strengthen the deliberation process and avoid duplications. Thirdly, they emphasize the need for coordination among EU entities through an AI coordination hub to manage conflicting interests. Fourthly, they highlight the necessity for the AI board to address national decisions to ensure consistent regulations and prevent misuse. Lastly, they recommend establishing a unit within the AI Office for learning and refining AI practices through collaboration with the competence centers of member states. This newsletter was narrated by Type 3 Audio for the Future of Life Institute. It was first published on May 28, 2024. To report an issue or give feedback on this narration, go to t3a.is.